Good afternoon, everybody. Welcome back to another webinar on trademarks. We're here with Matthew Grumbling, and today he's going to talk about trademark prosecution. So if you really need to know how to register a trademark, this is the webinar you want to tune in for. So, hi, Matt.
Hi there, Julie. How are you doing?
I'm good. How are you?
I'm doing well.
Great. And just one more thing I do want to add is that we are recording this session. So if you have questions or you need to go back or you want to watch it again later because you missed something, you can find it on the Surprise Economic Development YouTube channel.
All right. So with that, I'll start here. My name is Matt Grumbling. I'm a patent and trademark attorney with Wynn Tarbit. And I'm going to be talking today about trademark prosecution. Tried to demystify that word a little bit, that term prosecution, and just kind of give you an overview of how the trademark the acquisition of a trademark registration works. So I just kind of launch in here. We're going to be covering a number of topics today. One is what is trademark prosecution, and then, excuse me, we'll go over the stages of trademark prosecution. I'll talk a little bit about opposition, and I talked about a little bit of that last week, but we'll go over a few of the important points about it there, and then cancellation, and then I'll talk just a little bit about appeals. So trademark prosecution, the definition is it's the process of obtaining a federal trademark registration, and it includes filing the trademark application and responding to the trademark examining attorney. Now, there are a lot of terms of art that are used in the patent office. These are, my apologies for them. They tend to be very old-fashioned because trademark law is very old. It goes all the way back to the founding of the country. The original Constitution actually, trademarks actually come under the Commerce Clause, but a lot of the language has been adopted out of old common law relating to unfair trade practices and things like that. So the Lanham Act, which is the federal trademark statute, it adopts an awful lot of that language. So that's where we end up with things like prosecution. What does it mean to prosecute something? Well, it's an ex parte proceeding. Okay, what does ex parte mean? Well, ex parte means that you only have one party to the proceeding. It's basically you and the examining attorney. The examining attorney basically sits as a quasi-judge to decide whether or not you will get a trademark or not. Well, you'll get the trademark registration. And you may go back and forth with the examining attorney more than once. And that procedure is known as trademark prosecution. The communication from the trademark attorney is known as an office action, and your response is a response to an office action. The trademark prosecution procedure actually includes appeals, and I'll talk a little bit about that later on. So here's the stages of trademark prosecution. First off, you file an application. You file an application and a filing fee. Application is generally online. You can file paper files, but the trademark attorneys really prefer that you do this online. It's very simple, it's very easy, and I think you even get a little bit of a discount if you do it all electronically. You can do a word or a symbol or a combination of words and symbols. And you have to pick a class and a subclass, and this is where it gets tricky and where you might want to talk to a trademark attorney before you start, even if you file your own. The prosecution for trademarks is not all that complicated. And in fact, the trademark files tend to be about that thick. I used to work in an office right next to a guy who only did trademark prosecution. He would laugh at me because I would have patent files that were this thick and he would have stacks of these trademark files that were that thick. And so, you think about it, which one is harder? Well, I felt like having to deal with a lot of trademarks might be, kind of more difficult than a single patent, but we both kept plenty busy with the work we had to do. But picking that class and subclass is really key. Getting the verbal description of it correct is also key, because later on, after you file this thing, and maybe when you file it, you will have to show that it's being used in commerce, and we'll talk about that. The idea of a specimen of its use in interstate commerce later on. You will get an office action, and you'll have to file a response to the office action. Now, the initial office action may just be a notice of intent to register, in which case, if you filed as an intent to use, you will have to prove that you'll have to submit samples or specimens, I should say, of the use in commerce. More often, the office action will be something along the lines of, you may have to file what's called a disclaimer. Let's say you want to submit one that's like, and I'll use an example of an existing trademark along with something that it doesn't. Maybe not. Let's take one. I hadn't really thought about this. Let's say Acme. So Acme Biotech. Well, the thing about biotech is it's rather generic, and the examiner might say, well, you're not, you have to file a disclaimer saying you're only claiming the trademark biotech as it's used with Acme. So somebody else could do Akron Biotech or Summit Biotech or something like that. So, that's the kind of thing you may run into. You also might get an out-and-out rejection, and the examiner might say that, the examining attorney might say, well, your trademark is confusingly similar to another trademark, or it's merely descriptive, and you might have to show it. You might have to give a declaration of secondary meaning under the law. So these are things that you'll have to think about. You'll have to respond as the situation evolves in your communications with the trademark attorney. So I mentioned disclaimers. There's also the possibility you might get an examiner interview where the examiner may just call you out of the blue and say, or call your attorney out of the blue and say, hey, I want to do this, I want to allow this, but, I need a disclaimer or something like that. And you may be able to avoid having an office action. You may end up either handling everything by telephone or having very short communications by written communications with the examining attorney, I should say. So, there has to be a proof of use in interstate commerce. You can either file it with your application, or you can file it later on. In that case, you would file the application as an intent to use application, and then you would show later use of that trademark in commerce, and you'll have to submit specimens. So I thought I'd give you some examples of specimens just to give you an idea of what we're talking about here, because it may not be completely obvious what a specimen is of use in interstate commerce, especially where you're talking about maybe something on the internet. So I picked one I picked Google, and this is actually a screenshot of the result that you get when you search Google and you click on one of the earlier instances of Google. And you can see up here we have at the very top, it says that it's a word mark, and the word mark is Google. And then we have the the goods and services covered, and we see the description of it: providing electronic mail and workgroup communication services over computer networks, providing multiple user access, blah 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 blah. And those are those descriptors there: the class and subclass, the IC 048, US 101, etc. And then the description that follows that is very important, because you need to show in your specimen that you actually are conducting interstate commerce for all of those things. So let's just look at the specimen that they submitted. And there it is. That's part of it. Now they actually submitted 3 pages of their help page plus their search specimen. So what I would point out here is you can see it clearly up here that this is from www.google.com. So they have a URL that's registered. They have Google ! Now down here over the search box, they have search the web using Google, and they have Google search here. And of course they have their very clever I'm feeling lucky, which it's not going to be Google search, obviously. And then you have down here, you have a copyright notice. And over here we have, we have some other things that you can click on. I'm not even sure that this is current, but what you do see here is that there is, and if you've used Google ever, you know that this changes. It changes, with the seasons and whatnot, maybe special occasions and things like that. But the basic use of the word Google never changes, and its association with the search engine, which everybody is familiar with, is right there. So I'll give you another example. This one's for Snapple, and this one's for a product. And again, here's your word mark up here. It's Snapple. And then the goods and services, you have your class and subclass. And then you have what it covers, fruit juices and its first use and things like that. So let's look at that specimen then. Well, there you go. There's a label, and it shows down here the name. This is Apple Snapple, turns out. And it's apple soda pop, and it's just its distributor here, et cetera, et cetera. Let's look down one more. This one is it says Snapple all natural juice, apple and strawberry, and then it's got a bunch of stuff on there. So those are their specimens for use in commerce. Fairly straightforward. Obviously you're not going to send in a bottle with the Snapple label. You can send in an exemplar of the label, and that will be sufficient. So I want to kind of rehearse or go back over some things. Like, I wanted to mention the principal register. If you don't, your goal when you file a federal trademark registration in general is to get on the principal register. It gives you a lot of different things. I've mentioned this in previous presentations, but it's worthwhile kind of reviewing this. You get nationwide constructive use and constructive notice. What does that mean? Well, it means once you get on the principal register, it tells the entire country basically that you are using this particular trademark in connection with the goods and services that are listed in your trademark registration. And it puts everybody on notice. And why that's important is because notice is an important part of the law. You can't really hold somebody liable for something without letting them know what they're doing wrong. It also allows you to go after them for up to triple damages, so-called treble damages, because once they have notice, then and they are on notice that they shouldn't infringe your trademark. So after 5 years on the principal register, the trademark becomes incontestable. What that means is it really can only be overturned on the basis of fraud. All the other things like likelihood of confusion and it's merely descriptive or merely generic, those kind of go out the window, and all you got left is fraud. So, and fraud has to be pleaded, has to be specifically pleaded. So yeah, you can't just make a general allegation of fraud, or it will get tossed on basically on technicalities and pre-trial motions. And so you know. It takes a lot to prove fraud. You normally have to prove that somebody made a knowing misstatement and that they did it on purpose, and they did it with an intent to deceive. In this case, it would be to deceive the patent office. The principal register allows you to sue in federal district court, and because it's a federal question, you don't need to prove that, you don't have to show all the other things you would normally need to sue in federal district court, like with so-called diversity. You can sue in federal district court if all of the defendants are in a state other than your state. Well, what happens if they're, let's say you're all incorporated in Delaware, and then you wouldn't have perfect diversity there? Or what if one of the defendants and your company are both incorporated in Delaware? That's not diversity. So you would have to sue someplace under the diversity principles. You would have to sue probably in Delaware. Whereas because this is a federal question, it's on the principal register, you just sue in any district court where you can find basically where you can find the defendant. So, what it could be their state of incorporation, it could be their state of their principal residence, or it could be just a state where they are conducting a whole lot of their infringing activities. It could be your home state. So there's a lot of value to having that available to you. And then I have the no diversity or amount in controversy requirement. That's another thing. If you sue in federal district court and it's not a federal question, then you have to prove there's at least $75,000 worth of damages, because because your trademark is on the principal register. You can sue. You can sue whether or not there's $75,000 worth of damages. So it's pretty valuable. Here's one that is really helpful. Is if somebody's importing something, let's say a knockoff from an Asian country, which shall remain nameless, you can actually file a complaint with the International Trade Commission, and they will send customs agents to seize the accused infringing products and embargo them. And the other side won't be able to get them out without winning in the ITC, that maybe they were operating under a license or something like that. But in general, that's very helpful, because it's actually more valuable than an injunction. An injunction says, you have to stop doing something. This use of the federal customs agents basically enlists the federal government to enforce that injunction. Very helpful. So let's see. I mentioned treble damages. I didn't mention attorney's fees. So if you have willful infringement, that is the other, the infringer, whether you put them on notice and they continue to infringe, despite being on notice, they can be liable for up to triple damages. So, maybe this thing is only a $50,000 case when you start off, but by the time you end up adding in, the triple damages, it's a $150,000 case. And when you, throw in things like prejudgment, for, interest and things like that, and attorney's fees, it could turn out to be a whole lot more. And the attorney's fees are a big deal because sometimes the attorney's fees could swamp out the actual damages. What you might really be looking for is an injunction. But the attorney's fees to get that injunction might be a lot higher than the amount you could recover in damages. So being able to get the attorney's fees is, can be very useful. It might help to pay for your own attorneys, quite frankly. Let's see. If your trademark's on the principal register, you can file a complaint with ICANN, and you can use that to get a domain name that has been improperly improperly registered with ICANN. You can get that canceled. So so you can use it. It's an anti-cyber squatting tool on top of everything else. And that can be very helpful because there are people who are out there and they just look around for people using trademarks, and then they go out, they grab their domain names, and then they hold them hostage, and they want some, it maybe cost them a few $100 to reserve that domain name, and they want tens of thousands of dollars to get it back. And you can use this registration on the principal register as evidence that they're not entitled to it, that they're simply cyber squatting, and the internet provider has to cancel their use of the domain name. So I thought I'd go over again, the kinds of marks that end up being on the principal registry. Primarily, there are those that are fanciful, arbitrary, or suggestive. And fanciful is something that's a purely made up word, things like Exxon, Pepsi, Coca-Cola, things like that. Not sure the football team would count for that. That seems to be pretty generic to me, but that remains to be seen. Arbitrary words or English words that are repurposed. So something like Apple computer. Apple's a real word, but you wouldn't necessarily associate it with computers. And so if you put those two words together, then you've got an arbitrary trademark, and those are registrable on the principal register. Interestingly enough, Apple computer would probably be one of those words, one of those trademarks, where the examiner would tell Apple computer that they had to disclaim the word computer by itself, because after that's generic. It's only the combination of Apple and computer that is arbitrary. So that's something to keep in mind. And then there are suggestive words. They require imagination, thought, or perception to reach a conclusion of the nature of those goods or services. And I'm thinking maybe Best Buy might be suggestive. It might be suggestive of a store. What kind of store? Necessary electronics? Maybe not. You could say that that's also, you might argue that it's arbitrary. And I'm sure that, there have been millions of dollars in trademark attorney fees fought over whether something was arbitrary or suggestive, but it doesn't really matter because they both end up on the principal register. And then the supplemental register. This is where your trademark goes if you can't establish that it was fanciful, arbitrary, or suggestive. This allows you to register marks that don't meet all the requirements for trademark registration. It gives you a few other things. Like if the trademark is descriptive, it might end up there. It permits the owner to file for trademark registration in other countries. So it basically gives you priority. You have 6 months that you can go and try to and file registrations in other countries. It also allows you to sue in federal court. But what you don't get in the federal court is a presumption that the mark is valid as a unique indicator of source. You have to prove that, and you have to plead it, and you'll have to prove it in the first instance. You won't be able to just rely on that presumption and force the defendant to prove otherwise. Most importantly, probably, it doesn't allow you to cancel a domain name. And that can be pretty important, because if you end up on the supplemental register, your hope is to eventually one day move it to the principal register. And there you're going to want to gather evidence that your mark has attained secondary meaning. That is, that while it might be merely descriptive, in the minds of those who purchase that kind of good, your word has now, or your trademark has now come to stand for a particular source of that good or service. That's hard to do if there's somebody out there squatting your domain name. And they could be out there distributing. They could be using it as a meta tag for a lot of other people to be searching, and it could really muck up your story. So, if I were starting a business, I would try really hard to come up with a trademark that is, if not fanciful, at least not merely descriptive. Something above merely descriptive, because ending up on the supplemental register, while not the end of the game, it's an upstream swim to get over this the difficulty of being on the supplemental register. But you do get something for it. It's not like you get nothing. So if you've got that mark and you've invested a lot of money in it, soldier on and see what you can do, right? So I mentioned here, it can be upgraded to the principal register. If the descriptive term has secondary meaning, it might end up there. So what does it mean to be descriptive? It means it's either descriptive or deceptively misdescriptive. If it merely lists ingredients, quality, characteristics, function, feature, purpose, or use of the specified good or service. Some examples. Let's say you wanted to register a bed and breakfast, and that's all it's called. Maybe the title of a book or something like that. Yeah, that's not a good trademark. Chiropractic medical group. It's pretty descriptive. In fact, your chance of getting off the secondary, that one might actually be generic. Medical group is certainly generic. Chiropractic, it's getting into the descriptive. You might be able to get on the principal register, but if you get on the secondary the supplemental register, you'll probably be there for life. Generic names good or service. Examples for bakery. And I think anybody can put a sign up that says bakery and sell baked goods out of that shop. You're not going to be able to stop anybody from doing it, nor will anybody be able to stop you from doing it. If they sued you for trademark infringement, chances are it wouldn't make it past the word go. So if you use that as the name of your business, just know that it's not a unique business or a descriptor of products or services. You're not going to get that registered. Maybe the skin doctor for a dermatologist might be a really, that's now the skin doctor for some other things might be fanciful. It's something else, but it's not. But for a dermatologist, it's just flat out generic. So I've dropped out the parts about oppositions, and I'll just refer you to last week's presentation on oppositions and cancellation proceedings. Basically, in both of those cases, somebody or you maybe decide that a competitor's trademark is too similar to your own, and you want to have it canceled. You file a petition. You eventually will work toward having discovery, and you'll have a trial before the Trademark Trial and Appeals Board, and they will decide on, and they may have an oral hearing there, and then they will decide whether or not whether the mark will be canceled. So at the end of either ex parte prosecution or any of those opposition or cancellation proceedings, one of the parties, if there's only one party, like in prosecution, or one of the parties in either opposition or cancellation proceedings, can take an appeal. Now, there are two stages of the appeal. The first stage, and I say maybe three. There are at least two, maybe three. I'd say that the third stage is a very, very long shot. So the first stage is with the Trademark Trial and Appeal Board. There will be a panel of senior trademark attorneys, and they're administrative trademark judges, and they will hear this appeal. And it's very similar in a sense, and I'll just talk about from the prosecution standpoint. Since there's only one party, you would file an appeal, and first a notice of appeal, and then a brief on appeal. The trademark attorney would file a response to that, called an answer, and then there might be an oral hearing if the trademark, the TTAB grants an oral hearing. Everything's on the written record. There may be an oral argument, but this isn't like a real trial. This is much more like, this is a very abbreviated oral argument, usually not over an hour. Usually both sides get about maybe 20 minutes to half an hour to present their position. And then there will be a written decision in that case, and that will go into the file, and it will either be, the TTAB could do one of three things. It could just flat out grant the trademark registration. It could remand it to the attorney, or it could uphold the attorney and tell the attorney that, and basically, tell the trademark attorney that not to register the trademark. So after that, the next stage is one of two ways you can go. And let's say you filed for your trademark registration. The examining attorney rejected it. You sent it up to the TTAB, and the TTAB agreed with the examining attorney. What do you do now? Well, you can pick one of two routes, and only one of the two. The most popular one is that you appeal to the Federal Circuit Court of Appeals, which hears all appeals from the Patent Office, and it hears it hears also probably about 90 to 95% of patent appeals, and a good number of trademark appeals, because oftentimes patents and trademarks kind of overlap. But they hear all of the appeals directly from the Patent Office, Patent and Trademark Office, and again, this will be entirely on the written record with an oral argument. So you better make sure you've got all your ducks in a row before you go up to the Federal Circuit, because you'll get it'll be a 3-judge panel, and they will hear both sides. They'll probably give each side, I think it's about a half an hour to talk. they will issue a written opinion based on that. The other way you can go is you can file directly in a district court. You get so-called de novo review. So instead of being limited to the written record, you could actually have depositions. You could actually put in new evidence. Let's say between the time you appeal to the TTAB and the time you're ready to appeal to the next higher level, you've done a whole bunch of surveys and you've done a whole bunch of market research and whatnot, and you have a whole bunch of additional evidence that you want to throw in there, let's say to show secondary meaning or something like that, then you would, this would be the way to go, because this allows you to file this case in district court. Basically, it's a complaint against the commissioner of trademarks, and seeking to compel them to allow the trademark to be registered on the principal register. So you can have discovery, you can have new evidence, you can have oral testimony, all sorts of things. If you're not happy there, you can appeal to the federal circuit, and the same things apply again. In that case, going from the district court to the federal circuit, it's based on the written record and a brief oral argument. It's really not a very long oral argument at all. So the third level of appeal is to the U.S. Supreme Court. Now, the Supreme Court has to grant certiorari in that case, and they rarely ever do. The number of trademark appeals that they hear is very small. They tend to deal with issues that most trademark folks, trademark applicants, trademark attorneys even, and don't face very often. Or, in the last few years, there have been a couple of trademark cases that have had to do with the patent office refusing to register certain marks because the patent office considered them to be scandalous or disparaging. And the Supreme Court has sounded off and said, well, but you've got to balance off the trademark applicant's First Amendment rights in considering these things. But those are few and far between. Your average trademark appeal, if it hasn't made it past the Federal Circuit Court of Appeals, you're probably not going to make it to the Supreme Court. That appeal, and I should say here, actually appeals from the district court can actually go to any Federal Circuit Court of Appeals, not just the Court of Appeals for the Federal Circuit. So if you file this district court proceeding in Arizona, it would go to the Ninth Circuit. If you filed in Illinois, it would go to the Seventh Circuit. But my point here is you have 2 bites at the apple, and you actually have 2.5 if you first go to district court. I should put in a caveat here on the district court one. It's more expensive. And if at some point the judge in that district court decides that your appeal was frivolous, you could end up paying the other side's attorney fees. That's probably not going to happen if you go directly to the Federal Circuit Court of Appeals and then just stop if you lose. So the district court has it's got a little bit more risk to it. But there are enough upsides that if you have found yourself in that situation, you might think about going that direction. So anyhow, that's pretty much it for trademark prosecution. I want to thank you again. Here's my contact information down here. Again, you can find us at www.ntfplaw.com, and you go there and you can find my bio and whatnot. So Thank you for your attention, and I'll turn things back over to Julie.
Thank you, Matt. That was great. Remember, this session has been recorded, so if you need to go back and you need to listen to something, go right ahead. So we're going to have 2 weeks off from webinars for the holidays. Matt will be back with us on Tuesday, January 5th to talk about trademark strategy. So thank you, Matt. I hope you have a great holiday, and we'll see you next year.
All righty.
Thanks.
See you next year.